Good morning, El Paso Cougars. We're going to spend our late start this morning talking about tort liability, not the most enjoyable topics to come back to on a Monday morning, but something that's critical for us to discuss. Just as previous things we've talked about, I want to start off with a broad definition of what tort is. Tort laws offer remedies to persons who have been harmed or perceive that they've been harmed by the reckless actions of others. It usually involves state law, and it's based on the legal concept that we're liable for the consequences of our actions. In layman's terms, tort is something you sue someone for doing to you. When we're looking at tort in our arena, we look primarily at two categories: intentional tort and negligence. So first, want to look at and kind of define what each of those is. Intentional tort would be an action committed by a person with the intent to cause harm to another while understanding the harm their actions might cause. Negligence is different. Negligence is the failure to maintain a standard of care that a reasonable individual would be able to maintain. And when we're looking at our classroom environments, there are typically four elements of negligence. One is the duty that we owe to our students. Supervision is a good example. And then there's a question, and was there a breach of that duty? Did the failure in the duty cause injury to the student? And then finally, was someone injured? Tort liability for educators is a serious issue. Our primary goal is to teach our students, but we also need to provide them a safe environment, one that's conducive to their learning. It's also important to note that as we're working with our students, we are close with them each day. And that can put us at an increased risk for liability concerns, especially as we work with students with some of our more significant needs. Specifically, our students who might receive accommodations through a 504, or our students with exceptionalities who have IEPs. So I do want to go through and just discuss a few examples of tort liability that we see in education. There are some examples of tort that I don't really go into depth here, and they're typically tort related to property, things like trespass, or trespass to chattels, or conversions, or theft. So really the first example I want to go over with you is staff negligence. And we talked about general negligence just a minute ago. But if that staff negligence results in the harm of a student, the educator could be liable for that harm. Now, courts have generally ruled that schools have a duty to supervise students, but we're not solely responsible for our students' safety. And then generally, if we exercise reasonable amount of supervision, we're not typically held liable. And so another area of negligence would be in maintaining our facilities, or the structure of our buildings, with the goal of ensuring the safety of our students. If we don't have adequate safety features in place for our students, for the typical use of our facility, we can be held liable for injuries that occur. I will say that as I did research for this, they talked about some of those most extreme cases when students can be injured at school. And specifically, one of the resources spoke regarding school shootings. And that in those cases, specifically after Sandy Hook, when parents were wanting to hold the school liable for that atrocity that had happened there, courts ruled that the schools were not liable for that individual's actions because they had taken reasonable precautions to ensure the safety of their students. We spoke last week, or actually I shared a resource with you last week about ADA compliance and discrimination. And so Another area where schools can be held liable is in discriminatory harassment, which is harassment based on those items covered by the Civil Rights Act and the ADA. We can avoid liability if we work to prevent the harassment proactively. Once we find out that harassment has happened, if we investigate it thoroughly, and then, of course, always wanting to comply with the provisions of the ADA to ensure that our students have equal access to education. Now, if we don't do these things, that's when we can face liability. And also, I did want to specifically mention that we can be held liable if we're not providing our students with exceptionalities, equal access to all of their opportunities across the school day, specifically talking about being excluded from field trips and things like that. We also spoke several weeks ago about bullying. And bullying is also something that schools can be held liable for if we fail to adequately act to prevent either in-person bullying and cyberbullying. And the cyberbullying is a new wrinkle to this because, and I believe I shared this with you a few weeks ago, that schools have the right to take disciplinary action regarding cyberbullying, even if it doesn't happen on their school grounds. And because of that, the resources that I reviewed for this infer that schools can be held liable if they don't take reasonable actions to prevent that cyberbullying. Now, one thing that we really try and do is never restrain or seclude a student, right? That's why we specifically use our emergency safety interventions, our ESI procedures. And that's because we can be held liable for false imprisonment. And so in the normal function of our day, things like sending a student to the office or detention or ISS, that does not open an educator up to liability. What can open an educator up to liability is when the actions that schools take are not reasonable and they cause undue mental and physical stress. And some of the examples that were provided in the resources were duct taping a student's mouth shut, locking them in a closet, and tying them to a chair. And I would hope that I don't have to say that none of those are acceptable in any way. Now, assault and battery. So when I'm talking about this, I'm talking about two things, obviously. And sometimes I think we when we're thinking about assault, we're actually thinking about battery. Battery is purposely harming or offensively touching another person, while assault is acting in a way where someone believes that you're going to hurt them. Now, most of the time when educators are accused of assault and battery, it's in the course of disciplining a student or preventing a student from hurting a peer. Now, generally, courts are hesitant to interfere with an educator's ability to discipline, except when the educator is found to have acted unreasonably, cruelly, and excessively, or when the educator's intent was to harm the student. And that's, again, where those emergency safety interventions that our district has adopted, that our state has adopted, mandated, are so important. Now, this last one, student suicide. And it's really important to talk about, even though it's a difficult topic to discuss. And even though we work hard to assess our students' well-being as a whole child, there's horrible things do still occur in schools across our country. If we're providing a safe environment for students, it helps prevent our liability for injuries that might occur. But in the case that a student is injured, parents can still say that we have failed in our obligation. If a student passes away, that can be a wrongful death claim. Generally, schools have been found by courts to be liable for a student's suicide if they have been reckless in carrying out their obligations to the student, if they have not warned a student's parents of the risk of suicide in a reasonable way, or if they have created a special danger of suicide. So, of course, it's critical that we do everything we can do to avoid tort liability. And not just for the important reason that we're protecting ourselves, but also that these are good practices to create a safe environment for our students. We all need to be aware of our legal responsibilities regarding maintaining a safe environment for our students. Every one of us have students in our classroom or work with students at times that have legally binding documents that detail accommodations and services for them. And so I'm talking about 504 plans and IEPs, and we need to be following them. We need to routinely inspect the school facilities for safety concerns. Now, some of these are not necessarily going to be your job all the time as a classroom teacher. However, you can be aware of, things that you see around the school that might not be safe. When a concern arises, it's our job to be quick and reasonable in our response, especially when it regards student safety. Our district employs counsel, and it's our job to seek that legal counsel when appropriate. The Office of Civil Rights shares with our district guidance documents regarding, students' rights and access to education. And when we receive those, it's important that we review and then follow them. Our district and we as a building, we've established rules and procedures related to student discipline, and it's important that we follow those and be not just for consistency's sake, but also to avoid tort liability. And then finally, we spoke, I believe it was a week ago or 2 weeks ago, about FERPA. And it's so important that we maintain FERPA to help ensure the privacy of our students. At the district level, the district's role is to create effective policies, administrative procedures, and staff training that promote student safety and the creation of an environment conducive to learning. And then our roles, your roles as classroom teachers, my role as an administrator, is to know those policies and then follow them. Now, there are several board policies. I did not list every board policy that was related to every example above, but they are there. There were a few that I wanted to point out to you. Board policy BBE states that the district does employ an attorney. Board policy EEB states standards for the safety in our facilities. Now, board policy EBC is about the reporting procedures when there are safety and security concerns. But there was one specific point that I wanted to point out to you, and I'm going to read it to you. And it's staff immunity. No Board of Education, board member, superintendent of schools, or school employee shall be liable for damages in a civil action resulting from a person's good faith acts or omission in complying with the requirements or provisions of the Kansas School Safety and Security Law. There's similar language in policy GAAD about child abuse that state law provides that anyone making a report in good faith and without malice shall be immune from any civil liability that might otherwise be incurred or imposed. Board policy GAAF reviews those emergency safety procedures that I referenced in terms of when and specifically how to apply seclusion and restraint procedures when appropriate. Board policy JDDB discusses reporting to law enforcement. And then board policy JGFG, again, kind of has that liability piece that Kansas law provides protections from civil liability to any person who, in good faith, renders emergency care or assistance to any person. So, we can do everything right, and it doesn't ensure that we will not have a lawsuit filed against us as a school or even as an individual, because we live in a society that is becoming increasingly litigious. There are some defense strategies for schools and educators. And generally, courts acknowledge that there are times where educators' actions are justified. When we look at intentional tort, the primary areas of defense are self defense, defense of others, defense of property, and then acts of necessity. In terms of negligent tort defense, there are a couple of concepts that are at play here. And the first is the assumption of risk. And that's generally that students and families understand the risks inherent in the situations they're in. That's a big part of why permission slips are signed for some activities where injuries could occur, specifically sports. There's also the concept of contributory negligence, where the victim's actions contributed to their harm. And then also the statute of limitations, where there's a statute of limitations for each specific crime, and you can't be charged once that time has run out. Ultimately, our risk is going to be minimal if we're utilizing our good judgment and our common sense. But the resources on this issue inform us that any of us could be subject to a lawsuit. I know that's not the happiest note to end it on, but I will say that, as we work through any issues like that arise, I'm always available to be a resource for you, and anything that we encounter, especially when we're in these situations, we will work through together as a team. And with that, I want you to take some time with your grade level teams just to discuss this issue. And if you generate any questions, please send them my way. And I'm always more than happy to meet and talk about this. Now, I did use some references for this, so I'm going to share them with you. With that, I hope you guys have a pleasant Monday. Thanks.